Hi guys, today we're going to talk about jurisdiction and who can file for divorce and how to get jurisdiction over your spouse. So when you fill out divorce paperwork, you can see the form FL100 and it says on number 2, someone has to reside in California in order to file for divorce, either the petitioner, you who is initiating the divorce, or the respondent. What does that mean and why do we need that? In order for the court to make decisions over you or your spouse, that person needs to be in the contact with California. And I will explain a little bit. So there's 2 types of jurisdictional topics. Number 1 is subject matter jurisdiction, meaning does the court have the authority to make decisions over division of assets, spousal support, child support, attorney's fees. And then there is a personal jurisdiction. Does the court have jurisdiction to make decision about that person? So for example, if the court orders that person to pay for child support and spousal support and attorney's fees. And that's why it's so important that whoever files has to be either a resident of California for 6 months and living in the county they're filing for 3 months. And what does it mean, domicile or resident? Meaning the intention to reside, to stay and live in that county, in that state. Now, the biggest issue arises usually when the other spouse does not live in California. If that other spouse is, quote, non-resident, how do we get jurisdiction over that spouse? Well, through 2 ways. Number 1, if the other spouse filed a response, meaning they filed a form FL120 or they appeared in the proceeding. And I'm talking about either appearance in the court contesting child support, spousal support, or something like that. And if they filed motion to quash summons because they think they are not resident and they have been served somewhere else, outside of United States and California, that the court doesn't have jurisdiction over them. If they appear in the motion to quash, that is not considered as appearance, general appearance. Only general appearance will make them waive jurisdictional problem. Now, if they don't file a motion to quash summons on time, that's considered as waiving their right to object to jurisdiction. So now let's imagine we have a case where one spouse lives in California, files for divorce, and another spouse lives in Germany or China, anywhere outside of California. So what are the requirements if you hired someone to serve that spouse in another country? Does the court has jurisdiction and they didn't file for response, they didn't make any general appearance, and now you would like to have child support, spousal support, anything ordered by the court. And the court created exceptions. It's called if there is a minimum contact to that spouse, and I'm gonna list everything that's considered as minimum contact to California, then the court can make decisions over that person in the divorce proceeding. So number 1, the other spouse is present here. Well, obviously, if we serve them in California, that's not a problem. Or they're living here. They have citizenship. That's an interesting one. Even if they don't have meaning if they don't live here, but they have United States citizenship, then we have minimum contact. Or they consent to jurisdiction, or they waive jurisdiction by not objecting, or they appeared in a family court action, or they're doing business in California, or if they're doing business outside of California but it has an effect in California. For example, they're doing business in Denver but they're selling in California, so it's considered they have minimum contact in California. Or they have properties or any possessions in California, they have a car. So those, if any of those things are not present, so they're non-resident, you couldn't check off any of them, they didn't make it appear anything, can you still get divorced? And the answer is yes. you can get yourself a single status only, meaning you will separate, it's called bifurcation status only. You will separate the single status, meaning I'm single and I can check off that I'm single and be divorced, but all financial issues would need to be reserved until either that spouse at any point in time is in California or meets the minimum contact requirements, or you serve. I had a case where that other spouse was not an American citizen and he was traveling around the world, and he arrived at a hotel and my client had Mint.com access, and she was able to see that he checked in at the hotel, and we were able to hire a process server who stayed all night waiting in the lobby to serve that spouse in order to get court's personal jurisdiction over him. Anyway, I hope that was helpful, and I will see you soon. Bye!